Welcome everyone to the Ontario Caregiver Organizations webinar series. These webinars bring together caregivers and subject matter experts to explore topics of interest to caregivers. We do this to support and engage chosen family, friends, neighbors, really anyone who's caring for someone else. My name is Katie Muirhead, and I'm going to be your moderator for today. And before we begin, I'd like to take a moment to acknowledge the lands that we're on today. And while we meet on a virtual platform with folks joining us from across the province, I'd like to take a moment to acknowledge the importance of the land we each call home. I'm joining you today from the city of St. Catharines in the Niagara region, which is the traditional territory of the Haudenosaunee and Anishinaabe peoples. This territory is covered by the Upper Canada Treaties and is within the land protected by the Dish with One Spoon Wampum Agreement. Today, this gathering place is home to many First Nations, Métis, and Inuit peoples, and acknowledging this reminds us that our great standard of living is directly related to the resources and friendships of Indigenous peoples. If you'd like to learn more about the lands that you're joining from today, you can find more information at native-land.ca. Our webinar today is called Succession Planning 101 for Caregivers. What happens to them if something happens to me? It's a common worry and question that many caregivers have. Having a plan for the future is often on our minds, but there are many uncertainties on how to do this. An estate plan, for example, can help you decide what happens to your finances, property, personal items, and most importantly, how your care recipient will continue to receive the support they need. In today's session, we're joined by Brendan Pooran and Karen Bell to talk more about microboards and what they are and how they can support your care recipient, Henson trusts and their role, and wills or estate plans and what's involved with that. So I'd like to introduce you to our speakers today. Karen Bell is an experienced executive director at Microboards Ontario. She has been working in the developmental services sector for over 20 years and has held positions at both local and provincial levels. Karen has chaired committees on communications and marketing across the developmental services sector and has supported One Voice advocacy initiatives. She's also the chair of the Communications Task Group for the Developmental Services Workforce Initiative of the Provincial Network. Brendan Pooran is the founder and managing partner of Pooran Law. He has extensive expertise in corporate law and often provides legal counsel to not-for-profit and charitable corporations. Brendan's legal advice also covers wills, trusts, estates, and disability law matters. And apart from being a lawyer, Brendan is a founding director of Plan Toronto, which we now know as Partners for Planning, and Microboards Ontario. He's also a member of CRA's Disability Advisory Committee and teaches critical disability law at York University. So I'd like to welcome Brendan to get us started.
Thanks very much for the kind introduction, Katie. I'm excited to be co-presenting with Karen Bell today from Microboards Ontario. I know we have a sort of a tight timeline here, so I'm gonna jump right into things. As Katie mentioned, I spend most of my days actually working with families on their estate and financial plans. Many of those families are caring for a family member with a disability, and so we work through some of the government benefits available to them and some of the nuances associated with putting such a plan together. Office is based here in Toronto with a couple of satellites in London and Windsor as well. In terms of our presentation outline, I'll talk a little bit about will and estate planning, what's involved with that kind of planning. We'll talk about a few different types of trusts, including Henson trusts, and I will hand it over to Karen to take you through a discussion about microboards. A lawyer's favorite slide, we've got our disclaimer here, which basically says we're sharing information with you, but if you require any advice related to your specific circumstances, it would be well advised to contact a lawyer directly. Okay, so as I mentioned, most of my practice involves working with families, and those families are often planning for a family member with a disability or someone else who is generally quite dependent on them. So I wanted to start off by just touching on a couple of key considerations to think about when working through your succession plan if you are planning for a family member with a disability. The first one is, how does your sort of estate plan, like what does it encompass? and how do all of the different components work together. I'm going to bring up a diagram in just a minute to further explain what I mean there. Management of property. So are there concerns related to your family member's capacity to manage property? And if so, how do you address those? And number three, is your family member in receipt of social assistance? In particular, are they receiving support from the Ontario Disability Support Program or for Ontario Works? And in those circumstances, what do you need to consider and think about in order to be able to provide for them without affecting their eligibility for such supports? This diagram is the estate planning blueprint, right? All of the various components that go into succession planning and estate planning. And so what it's meant to sort of convey is that it will take a while to put your estate plan in place, right? It's not a matter of sort of walking into a lawyer's office today and having the plan completed by tomorrow, because there are all of these different considerations to think about. On one side of the slide, we've got the various components that all work together to promote and facilitate future financial security. And on the other side, we've got sort of the roles and the sort of the people roles, the human resources that you require that you want to incorporate into your planning in order for your plan to be implemented and carried out according to your wishes. So I'm not going to go through all of these in detail, but I'll run through them at a high level very quickly. ODSP, or social assistance, we're going to talk about in just a second. That's the Ontario's provincial social assistance program for people with disabilities aged between 18 and 65. Tax planning, so in particular the disability tax credit and all of the benefits that stem from the DTC. The DTC is a way for a person to identify themselves as a disability in the eyes of the federal government. By doing so, there are a wide range of benefits that are accessible to them through the Income Tax Act. The RDSP, or the Registered Disability Savings Plan, is a long-term savings plan designed specifically for people with disabilities, in particular those who qualify for the RDSP, qualify for the DTC. The main benefit associated with the RDSP is that people may be eligible for up to $90,000 in government contributions over the course of their lifetime. Power of attorney documents. So these are documents whereby you are appointing somebody else to make decisions for you, usually in situations when you are incapable of making those decisions yourself. I'm going to talk a little bit more about POAs in a few minutes. Wills, most of us know that a will is a legal document that takes effect upon our death and allows us to do a number of different things with regards to our estate plan. Again, we're going to talk about wills and trusts as well. So you may incorporate a trust for various reasons. We'll get into a discussion about trusts. Life insurance. Often life insurance is used as a way of enhancing whatever you are, or to actually supplement any proceeds for your estate. So you may take out a life insurance policy, let's say to specifically fund a trust or to pay off some sort of liability, usually a tax-related liability that your estate would be responsible for after you pass away. And then housing and other forms of funding are often, these are sort of topics that have worked their way into the estate planning process over the last few years. We kind of have those connected to microboards because we found that microboards will often support the administration of services and supports and support housing models that you may develop. And so, the takeaway here is that there's a lot, right? And it's not meant to overwhelm you, but it's meant to help you think through all of the various components, again, that go into promoting future financial security. On the other side of the slide in yellow, again, we have all of the people or all of the roles associated with the various components. So an ODSP trustee to help manage ODSP benefits, an RDSP plan holder to manage the plan, attorneys, so people that you're going to name to make decisions for you in power of attorney documents, trustees that you'll need for your wills and your trusts and potentially your life insurance proceeds. And then when you think about microboards, and Karen will get more into this when she speaks, directors of those boards, maybe personal networks, support workers that the board may employ, or service providers or agencies that may contract with the microboard. So the second key consideration was management of property. I had sort of alluded to, a lot of, or some of the families that we work with, their family member with the disability may require supports when it comes to making a decision and when it comes to managing property. In those situations, you don't necessarily want to leave gifts directly to that person because in some circumstances, that could trigger the need for guardianship. And generally speaking, you're looking at trying to avoid guardianship at all costs. You really want to treat guardianship as a last resort. So when developing your estate plan, you want to include tools and instruments that would assist with addressing or supporting the person with managing their funds. So in particular, a trust could be very useful, right? Because what a trust allows you to do is set money aside in sort of a separate kind of taxable entity that is set aside to benefit your family member, but is administered by somebody else, is administered by a trustee that you would appoint. We'll talk more about that in a few minutes. Does your family member receive social assistance in the form of ODSP or OW? For the majority of our families, their family member, if their family member is over 18 and under 65, they are going to receive ODSP benefits. Now, ODSP, there are a number of different rules, all associated with eligibility, a number of financial rules. So rules related to how much you owe, or sorry, how much you own, in other words, your assets, then how much you earn, your income. We don't have a whole lot of time to get into those rules specifically, but generally speaking, a person on ODSP is entitled to receive up to, or is entitled to have up to $40,000 in assets in their name. There are a number of different types of exempt assets, but generally, if they exceed that asset threshold, they will likely be ineligible for benefits. And so if you pass away without a will, or if you pass away without an estate plan that has been properly structured, and your family member inherits from your estate or inherits life insurance proceeds that exceed the $40,000 threshold, they may be deemed ineligible for ODSP. And so you definitely want to structure your estate in such a way where ODSP benefits are not affected. And we're going to talk a little bit more about that in a few minutes. I've just sort of listed a number of different benefits offered under the ODSP program. The primary benefit is the income support, that direct deposit payment that a person would be eligible for on a monthly basis. The benefit is just over about, maximum benefits just over about $1,300 a month right now, but there are other benefits associated with ODSP as well. So dental, vision care, prescription drug coverage, hearing aids, medical transportation costs, and medical supplies. There's a special diet allowance. There's an allowance for disability-related items and services. There's a whole arm of ODSP that is dedicated to the provision of employment supports. There's some housing-related supports as well in place, depending on where you live. So the takeaway here, once again, is because financial eligibility is subject to income and asset limits, you want to make sure that your estate plan is structured properly. Let's move on and talk about how we do that. So will planning. Most people know what a will is. It's a legal document, again, that takes effect upon our death. But in Canada, more people than not actually pass away without a will. A will generally allows you to appoint beneficiaries from your estate. Those are people who are going to inherit from you. People to take care of your affairs when you pass away. So file your taxes, pay your debts, liquidate your assets, and pay your beneficiaries. Those are called estate trustees or executors. It allows you to set up trusts. And again, we're going to talk about trusts in just a few minutes. But if you are setting up a trust, it allows you to appoint people to administer those trusts called trustees. If you have minor children at home, so those are people under the age of 18 here in Ontario, it allows you to appoint a temporary guardian. Having a will in place also permits tax planning strategies to maximize the value of your assets. So when we're reviewing people's existing plans, we often notice that tax planning is missing. And what that results in is an unfortunate tax liability that the estate would be responsible for after the testator passes away that could have otherwise been minimized or in some cases completely eliminated. So that sort of a segue into the next point, which is that having a will in place often reduces the cost of administering your estate because of the decreased tax liability, because you're actually appointing somebody and providing them with instructions in terms of how to administer. And again, just to sort of reemphasize this point, having a will in place will ensure, or a proper estate plan in place, will ensure that eligibility for social assistance benefits is not affected. So how do we structure things in such a way where benefits will not be affected? Often that is involves the incorporation of various different types of trusts. Now, there are a number of different trusts that are recognized by the Canada Revenue Agency. We're just going to touch on a couple here at a very high level, and most of these are related to disability related planning. When we talk about a trust, and I sort of described the trust a little bit earlier, what we're doing is we're saying, me, I'm the settler, or I'm the person leaving instructions, and I'm saying I want to leave half of my estate or $200,000 from my estate in sort of this separate taxable entity. Think of it sort of in the same light as a corporation, right? So I'm setting money aside for the benefit of my family members, called the beneficiaries, to be administered by people that I appoint, called a trustee or trustees, as opposed to simply saying, I'm leaving my daughter 50% of my estate, or I'm leaving my son $100,000 from my estate. You're actually setting monies aside to be administered by other people for the benefit of your family member. When it comes to disability related planning, there are a few different types of trusts that we like to see incorporated into the plan, and we can go to the next slide. The most common type of trust that most people may have heard of is the Henson Trust. And I'll go to the Henson Trust slide. The Henson Trust is structured in such a way where the people that you appoint, those trustees, right, have absolute discretion when it comes to the spending of the funds. So in other words, you can't leave a binding direction which says make sure that rent is paid every month, or make sure that $1,000 is dispersed every year. You're saying to the trustees, I trust you to administer these funds for the benefit of my family member. You have absolute discretion. And if the trust is structured that way, then it is not considered an asset for ODSP eligibility purposes. There is also no maximum value, no maximum monetary limit that applies. So the trust can have $100,000, $1 million, $10 million in it. Person's ODSP benefits would not be affected. You can name alternate beneficiaries for the trust. So in other words, you can say if the primary beneficiary passes away and there's money left in trust, here's where I want the money to go. This trust is more often than not, or I would say in most of our situations, a testamentary trust, meaning that you are leaving instructions in your will for the trust to sort of crystallize after you pass away, or after you and your spouse passes away. You can also set this up as what's called an inter vivos trust, or a living trust, meaning that you are settling the trust now. There's a separate document that you are putting in place now in order to create the trust, and the trust would then hold some corresponding or some associated property. So I would say we're doing this in situations typically when families are coming to us and they're saying, I want to buy a condo, or I want to buy a house for my son or my daughter. How should I structure the ownership? And sometimes we'll recommend that they go the trust route, depending on their circumstances. With the Henson Trust, especially because it's absolute discretionary in nature, you do want to consider naming multiple people to take on the trustee role, and we'll talk a little bit more about trustees in a few minutes. On to the next slide. There is another type of trust called an inheritance trust that ODSP allows. This one differs from a Henson in that you can leave binding instructions, right? You can say, pay rent every month, pay the beneficiary a minimum of $2,000 every month, whatever you'd like. But the difference with this trust is that there is a maximum monetary value attached to that, and that is $100,000. For that reason, we don't typically find clients wanting to incorporate a Henson Trust into their will, but it is there as an option. We move on. The last two trusts are sort of tax planning in nature. So the first one is called a qualified disability trust. And not to confuse you, but this isn't normally a separate trust. It's more of a designation. Usually you're setting your plan up in such a way where the Henson Trust would qualify for this QDT designation. The benefit of the QDT designation is that the income generated by the trust would be taxed at preferential rates. So the income would be taxed at the graduated tax rate, as opposed to the highest marginal tax rate here in Ontario, which currently right now is about 53 or 54%. The main eligibility criteria for the trust to meet this designation is that the beneficiary must have the disability tax credit in place. Okay, moving on. And finally, the lifetime benefit trust. The lifetime benefit trust came about 6 or 7 years ago. It can be an incredibly impactful planning instrument as well. What this allows you to do is roll over proceeds from your retirement savings plan to this special lifetime benefit trust on a tax deferred basis. So let's say that you pass away and you've got $200,000 left in your RIF and you've got no spouse to roll those monies over to. You could roll the funds over to a lifetime benefit trust on a tax deferred basis, meaning that the full amount would be transferred to the trust, as opposed to the estate being on the hook for the tax liability, which on $200,000 could be about half of that. In order to qualify for the LBT, the beneficiary of the trust must be a child, grandchild, or spouse of the common law partner who is financially dependent on you at the time of death due to having a mental disability. The proceeds that flow into that trust then have to be used to purchase what's called the qualifying trust annuity, kind of like it functions kind of like a RIF, like a guaranteed income stream to the beneficiary for life. Finally, just a note on selecting trustees. So this is especially relevant, I would say, if you've got a Henson Trust in place. Top of the list, honest and trustworthy, right? And that goes without saying. But considering that the trustees have absolute discretion when it comes to the spending of the funds, you want to be able to trust them, right? That consideration, that characteristic is paramount, I would say, over anything else on this list. You want at least one of the trustees to be highly involved in the beneficiary's life, sensitive to their needs and wants. And you want people who understand the ODSP rules, who understand investments, or can access people who understand investments and income tax, who are good at record keeping, who are similar in age to the beneficiary, because the idea would be for the trust to be in place for the duration of the beneficiary's life. Beware as well of potential conflicts of interest. The reason that we put this on the slide is because often the testator, the person making the will, their other children are the trustees of the trust. They're also typically named as the alternate beneficiaries of the trust, right? So what the will says is, you know, my other children, let's say my son is my trustee's daughter, and if my daughter passes away, then my son or his children will inherit the remaining funds. There's an inherent conflict there, not saying that you don't appoint your son in that circumstance, but you want to think of ways to mitigate the risk of a potential conflict of interest if you think that may be an issue. That could be simply naming a joint trustee with your son for an extra set of eyes to provide that sort of check and balance. Okay. And finally, I just wanted to talk about powers of attorney. Powers of attorney sort of round out your estate plannings. We talked about wills, we talked about trusts. POAs give someone else the authority to act on your behalf while you are alive. And people who grant power of attorney, just like when they are making their wills, they've got to meet specific capacity requirements as well. There are 2 types of POAs in Ontario. The first one deals with your properties. It's called a continuing power of attorney for property. This allows you to appoint people to make decisions related to your property, your finances, your interactions with CRA, your housing, while you are still alive. Now, there are 2 ways of setting up a power of attorney for property. One is you can structure it such that the authority that you are granting to the attorney is applicable right away. So you sign the document, the attorney can make decisions for you, even though you're perfectly capable of making decisions yourself. Or you can structure it in such a way where that authority is triggered upon your incapacity, which I would say is more, well, I was going to say it's more common. I don't know if it is more common, because if you just sort of download the standard forms online, they default to the former, right? They default to the document being in place right away. Both the grantor and the people that you name as attorneys must be at least 18 years of age. The second type of power of attorney is called a power of attorney for personal care. This covers 6 different domains. So it allows you to appoint people to make decisions for you while you are still alive in areas such as healthcare, hygiene, nutrition, safety, shelter, and clothing. Okay. Obviously, the authority that you are appointing or the authority that you are granting to someone doesn't come into effect until you are incapable of making a personal care decision yourself. Both you as the grantor and the attorneys that you appoint must be at least 16 years of age. Just very briefly, some additional considerations to think through. Life insurance, we spoke about at the beginning of the session, a great way of supplementing your estate, but you also have to consider, who are the beneficiaries of these life insurance policies. If the beneficiary is someone who is also in receipt of ODSP, then you need your lawyer and your life insurance advisor to speak to each other in order to ensure that they are not the direct beneficiary, but that the funds can flow to a trust that you may have set up for them. Home ownership options is something that has become, I would say, quite popular, quite common, I would say, over the last 5 or 6 years when working through people's estate plans. How do they leave their home to their family member with a disability? What's the best way of structuring that? Microboards, Karen's going to get into in just a couple of minutes. And then accessing other types of supports and services developed dependent on the nature of the person's disability. For example, if the person's an adult and they have a developmental disability, we sort of talk about accessing support through Developmental Services Ontario. And pensions. Some of your pension plans may have survivor benefits for adult beneficiaries with a disability who are financially dependent on you. If that is the case, then you want to check in with them, try to figure out what that benefit looks like and how it would ultimately impact your estate plan. In terms of next steps, it sounds like there's a lot to do out there, but I would say take it in stride, prioritize your planning, gather all of your information. So a lot of lawyers' offices will have comprehensive sort of estate planning questionnaires that will help you to gather your information, identify the people who are going to be involved in your plan. Remember all of those roles that I spoke about at the beginning of the session, and then select your professionals, right? Your lawyer, your tax advisor, your independent facilitator, your accountant, all of whom have a background in disability-related planning if you are indeed planning for a family member with a disability. I want to point you to an excellent resource that we authored and partnered with Community Living Ontario on. It's called the Inspiring Possibilities Estate Planning Guide. It's a free publication. It covers all of these various topics in greater depth. Feel free to jump on our website, look for this picture, click on it, and you can download the publication. With that, I'll turn it over to Karen.
Thank you, Brendan. Hi, everyone, and thank you to Ontario Caregivers for inviting us here to present to you today. So I'm going to take a few minutes to just talk to you about microboards, and I'm going to start with the most obvious question. What is a microboard? It is when friends and family of a person who has a disability or who needs help with making daily decisions, and they come together and they actually create a not-for-profit organization. That not-for-profit, a microboard, has one purpose, and that is to support that one person with making decisions and living their best life throughout their life. It is a permanent structure. It can only be dissolved when either the microboard directors dissolve it, like you would any nonprofit corporation, or when the person who is at the center of the microboard passes away. And it is a really great way for friends and family who are committed to supporting a person to kind of come together and work together to help support that person throughout the different stages of their life. It is founded on values and principles. Those values include being person-directed, including the person in making decisions that impact their life. It is supported decision-making, helping them understand the risk and benefits of every decision that they're going to make, and really just living a good life in the community. Microboards are not new. They've been around in BC for about 30 years. And some microboards out there have been running for as long as 25 years. So it really is a sustainable option for families who are thinking about that next stage when parents are no longer around, or when a sibling is going to step into that role of being a primary caregiver for their brother or sister. We can move on. So what's its role? As I said, its role is to support decision-making and supporting person-directed approaches. Members of the microboard help to expand connections, deepen relationships, introduce the person to new experiences, new people, new activities in their life. And one of its primary goals is to manage that nonprofit, manage that microboard. As I mentioned, it is incorporated. So board directors have fiduciary responsibilities, which means that they can recruit, hire, pay, supervise, support staff. They can be the employer of record. They can enter into a housing agreement. They can enter into a contract with an agencies. They can appoint a trustee for one of the trusts that Brendan mentioned earlier. The microboard can't be named as the trustee, but it can identify the trustee. The trustee could even be a microboard director. The microboard itself cannot be named as a trustee. And one of its primary goals is to support succession planning. So what are the benefits to the actual person? Why has a microboard been so successful? And there's over 1,200 of them out in BC. Why is it such a great option for families who are looking to plan ahead for their loved one's future? It gives the person a greater sense of independence and autonomy. They're involved in making decisions. They become empowered to express what it is that they want to do with their life. We have many families who learn about some of the interests and goals that their family member has, because in an environment that involves multiple people and multiple relationships, they feel more comfortable in expressing what it is that they would like to explore in their life. Supports are also culturally and age appropriate based on what that person wants and needs. So members do often switch out as a person ages. It might go from parents and aunts and uncles to siblings and cousins and friends to even the next generation of support. People feel more connected to their community, and it also is known to expand the number of people in a person's life. And we didn't just make these things up. The University of British Columbia did a study back in 2021, and they did research project on the impact that a microboard had on a person's life. And these are the actual outcomes that they found through that study. So what are the benefits to families as caregivers in having a microboard in place? It reduces pressure. It gives you an answer to, or some comfort in knowing that there is a supported permanent structure in place comprised of your loved ones, nearest and dearest, who are going to help them navigate life after a parent's no longer involved. It also helps families now, because a microboard can help with, as I said, with all of the day-to-day responsibilities. They can be managing staff, they can be hiring staff, which helps free parents up to have a little bit more of their own time. And we've seen this, we've talked to families who've said, I'm finally getting to a point where my husband and I can take a vacation, where we can go out for dinner and not have to worry about what is happening, because we know that there's a wraparound support in place of people committed to support their son or daughter. It also, one of the biggest impacts is with that next generation, with siblings who are going to step into the role of their parents. They find that siblings are often more than willing to do it. They expect that they're going to do it. They start making life decisions from a very young age so that they are there when they're needed. But they also feel a lot of anxiety around managing their siblings' finances, taking care for their mental health, and navigating the developmental services system. But because there's a microboard in place, they don't have to have every single piece of that puzzle, because the microboard directors all know what's been going on. They've been involved in that person's life, so they can really help the sibling or whoever that next generation of support is step into that role without having the anxiety of having to fill their parents' shoes, or to be that all-encompassing one-stop, all the knowledge is here. It also helps siblings have a bit of a balance in their life. They don't have to, they've got support around them, so they're not being, having to spend all of their time having to make big career changes, big moves to support their sibling. And it also reduces the tension of a person with a disability having their sibling now be their caregiver. And we've heard this a lot from families that a person with disability wants their sibling close, wants them involved, but doesn't want them being their primary caregiver. So it helps protect that sibling relationship and that sibling dynamic. It also reduces the chance of a person going into crisis. I've worked in the sector for a long time. Brendan's worked in the sector for a long time. We all know what happens at times when there isn't a plan in place and something happens to one or both parents. And a person's life can be turned completely upside down. They sometimes have to leave their home. They sometimes have to explore new situations, new living arrangements, new people in their life. But because there's a microboard in place, there's far less chance of that happening because there are people who are around for the long haul who know how to know this person really well, know what supports are in place, know what that person needs, and know how to support them in making decisions. So I know you're all saying, when can I start? How do I get a microboard set up? It is something that you want to start long before you need to start it. So now, I guess, would be the best time. You don't want to start it when there's a crisis or when you have to do it quickly. They take time. You need to put your microboard members, directors together. You need to invite them. They need to understand what a microboard is. They need to understand supported decision making. There's a lot of planning that goes into it. I'm not saying that it can take years, but you do want to be thoughtful because these are people who are going to help support your loved one. We do have families we've connected with who have children who are still minors, and they're looking towards developing a microboard. So they're starting to actively seek out who would be their directors while their kids are still in school. And also determine if it's right for you and your family member. There is a lot to learn, as you can guess. Didn't even get into governance all that much. So we have a lot of workshops on our website. We have family connection nights a couple of times a year where you can actually hear how a microboard is working with families who have one and ask them whatever question you want. We also have peer mentors for people who are interested in connecting with a family and kind of having someone help them walk through the process of getting ready for a microboard. And then you can always reach out and talk to me when you want to talk about it a little bit more. We also have some stuff that's coming down the pipe where we're actually going to be able to support families. So the best way to learn about that is to get on our newsletter distribution, because that's where we'll be announcing this project in the next couple of weeks.
Wonderful. Thank you so much, Karen and Brendan, for that presentation. A lot of information for our guests to work through. And as a reminder for folks, we are recording today's session, and there's slides in the recording and the resources, the links that are being shared in the chat. We'll get to all of your inboxes for folks to take a deeper dive. If people do have questions for Karen or Brendan, please put those into the chat. We've got some time now to do a bit of a Q&A. We just had one come through, so let's read through it together, shall we? So the question is really around somebody who has the level of knowledge around the disability space and financial services that can explain all of the acronyms, the ODSP, the RDSP, DTC. We do sessions on this quite often, which helps break it down for folks. But do you have any tips or strategies, suggestions on professionals that might be able to sit with a caregiver and work through some of that? Brendan, I see you came off mute there.
Sure. Yeah, I may suggest that a good place to start would be that publication that I pointed people to. That will sort of provide a really comprehensive explanation of each one of those components. I mean, our firm works around the province, helping folks with the implementation and development of all of those plans. I know that an organization by the name of Partners for Planning also has a resource directory on their site as well, where you may be able to find professionals.
Great. Thank you. It is a unique scenario for each unique circumstance. So I think getting started through the Inspiring Possibilities Planning Guide might be a great starting point for folks. And yes, we'll get you the links to the planning checklist. A question around some of these pieces in my experience, and you might tell me differently, with things like Partners for Planning, micro boards, it tends to, maybe it started around the developmental services sector, and we do have caregivers that join us with different caregiving backgrounds. So maybe they're supporting an older adult with a dementia diagnosis or a cognitive disability, stroke, brain injury, the list goes on. Would you say that these tools and resources and micro boards are also something that would align and support folks with the range of caregiving experiences? And maybe Karen, I'll put that to you to kick things off.
For sure. It, as I said at the beginning, a microboard can be put in place for anyone who needs help with making decisions on a daily basis, or with living in the community on a daily basis. So we have had families approach us where there is acquired brain injury. We have had physical disabilities where a person has felt that as they're getting older, they're needing to trust the people around them a bit more to help them make sure that their wills and their arrangements are upheld. So they're looking in microboard. We have had families who have a family member with significant mental health issues, including dementia, where a microboard can help ensure the person's supported into the future. And we've also had someone interesting who is getting older, and she doesn't have a lot of direct family. So she wants to put a microboard in place because she doesn't necessarily trust the medical system, doesn't trust that decisions are going to be made to her liking. So she wants a microboard to help make sure that her wishes are upheld. So it has broad application for sure.
Great, thank you. And maybe while we're on that topic, I see a question around referencing some community resources and organizations like their ACT team or their local community service providers. So maybe we can take this minute to just clarify the difference between those community organizations like the local CMHA or community living, or their social work services, and how that differs from micro boards. So yeah.
The microboard is its own little time, and jump in, Brendan, is its own nonprofit organization. So it is incorporated with usually about 5 to 9 directors who all have a relationship with that person who has a disability or who needs support, and they are incorporated. So they will often have a name like Darcy's Anchor because it's all about Darcy, and the people around it are his anchor. So it's very different from an organization that's offering lots of services and supports to many, many people throughout the community. This is one person, people who know and love them, who that person loves and trusts the most, helping them navigate through their life.
And then the microboard itself may then interact with those other organizations, right? The community living, it's the CMHA, in terms of supporting the individual.
Mm-hmm.
Thank you for that clarification. So it doesn't mean you can't access those other community-based or publicly funded services. The microboard is really a vehicle to take some of that decision making, the weight from a single solitary caregiver, and spread that around to a group of invested individuals through an organized format to provide ongoing support to that care recipient.
Yeah.
Yeah.
And that
Okay.
microboard, as Brendan said, could hire an agency to provide some of that support. Absolutely.
Mhm.
But it still stays with the microboard.
Great. Thank you. Hopefully that clarifies for folks. It's not a one or the other. It can be all and many at the same time. So a few questions around that seniors piece and planning for seniors, and I think the response here would be very similar, regardless of the age of the care recipient and the diagnosis and need. Is there are some limitations in funding sources and things like that, but approaches can be similar, whether it be through micro boards, different trusts, and public service funding. Would you agree that the information you provided today can align across the lifespan and across diagnoses?
Yeah, I would say some of it for sure, others perhaps not, right? So it like, for example, a lot of the tax related planning, the disability tax credit, the registered disability savings plan, maybe not for seniors, but for folks under 60, are directly applicable. I think Karen spoke to the applicability as well of micro boards. Some of the trust planning, perhaps, but I don't know, if there may be different types of trusts that you consider for seniors as well. But I think overall, conceptually, very much so, right? Like the importance of a will, the importance of power of attorney documents, are directly applicable.
Great. We just had a question come in around the nonprofit financial implications of incorporating as a nonprofit. So, can you just clarify for our audience, are there setup fees or additional costs associated with getting a micro board started?
You want to, you want me to go for it?
Go
Karen?
for it.
All right. I mean, some people decide to do the setup on their own. I mean, it is a legal instrument, so often people may involve a lawyer for support. In terms of, I mean, if you're doing this on your own, you're not incurring legal fees. Obviously, there is a registration fee, a fee for name search as well. So you're probably looking at a couple of $100, depending on whether or not you incorporate as a provincial corporation or a federal corporation. And then depending on what the microboard is going to do, there may be some annual costs associated with that, such as insurance.
Great. Thank you. And I think those tools and resources and information sessions that you mentioned, Karen, probably dive a little bit more deeply into the nuances and considerations of establishing and running a microboard. So if folks want to get more information on some of those nuances, you can check out some of those resources and sessions. Did you want to add to that, Karen? I saw the unmute. No?
No, I'm
Okay.
good.
Okay, great. A question came in around capacity, which is always challenging when folks have or do not have capacity to make decisions. And in some scenarios where mental health conditions are at play, there may be episodic situations where this can change. And do you see application for something like a micro board, or is it possible to establish a micro board when you have someone with mixed capacity? And are there, I guess, a secondary follow-up, are there alternatives that folks can consider for future planning for folks in that category? Brendan?
Yeah, I mean, yeah, capacity is always a little bit tricky, but I mean, I think it's especially beneficial for folks who may require support when it comes to making decisions, who may be deemed incapable by others, because you've got a group of people there who have a close relationship with the individual to interpret their will and preference and to help them navigate the decision-making process. I think in terms of other instruments, I will say anybody who can give a power of attorney should have power of attorney documents in place as well. So, we know within the mental health community, a lot of folks will sort of develop power of attorney documents with very prescriptive instructions in those documents to account for situations where they may become episodic. So microboards, absolutely, from my standpoint, at least, directly applicable. I would also say power of attorney documents are very important as well.
Thank you. Just scrolling through the questions that are coming through here to see if there's anything that we have missed. There was a question around sort of immigrant communities and things to consider when managing cross-country wills and powers of attorney, which might be a little more complex than we can get into in this session, but I'll open it up to see if there are any thoughts around folks that are long distance caregiving for people out of country or out of province, and any considerations that they might want to have in supporting people.
I think the one point I'll make is that if you are working through your estate plan and you've got foreign property in place, the best approach is often to ensure that you've got a will in that jurisdiction as well, and to make sure that that will doesn't revoke the applicability of your will here in Canada and vice versa. So often you may have a lawyer here working with a lawyer abroad as well to sort of optimize the plan.
Great tip, great suggestion. How to set up a Henson Trust Fund. I think maybe you touched on that in your slide deck, but do you have quick pointers or a starting point for folks that this might apply to them and they want to get more involved and engaged with a Henson Trust?
Yeah, I mean, keep in mind that most Henson trusts are testamentary in nature, so meaning that you are leaving instructions in your will for it to come into place after you pass away. So typically the whole sort of Henson Trust planning is going to be part of your broader will and estate plan. So it would be, the next step would be speaking to a lawyer.
Thanks. Now, for my own interest, is this something that folks can connect with their local financial institutions on as well? I know sometimes when we bring folks in to talk about estate planning, especially for people that might have limited incomes, there can be some suggestion to go to your local bank where you're already banking and they have financial planners and people there that can offer sort of free insights and advice. Would they have knowledge and understanding about different trusts like the Henson Trust that they can share with people?
It's hard to generalize, like they may or may not. I mean, at the end of the day, it's a legal instrument. So I mean, once a Henson Trust is established, so let's say you leave instructions in the will for the Henson Trust to come into play after you pass away, person passes away, estate's administered, money goes into the Henson Trust. It's now time to crystallize the trust. That typically involves a financial institution because there'll be an investment account or a bank account, a trust account opened at a financial institution. But they are looking to the legal instrument, right? They're looking to the will that would provide them with instructions and directions in terms of how the trust should be administered. So you may be able to find some financial advisors. I mean, there are financial advisors who specialize in the disability related planning area, but at the end of the day, you're still going to have to see a lawyer in order to develop your will and ultimately your trust. Again, there's an entire chapter on Henson Trusts in the estate planning guide, so that may also be a good place to start.
Great, thank you. Maybe I'll ask one final question before we wrap up, because this is something I get questions about all the time in the community around powers of attorney and wills. Can they be made without a lawyer? And so can the POAs and wills be made without a lawyer? Like there's people that download online documents and those sorts of things. Is that something folks can do? And does it hold up throughout that process? Is it still legally valid?
Yeah, I mean, it can be. I hesitate because they can be. So, I mean, look, there are power of attorney documents that you can download from the Ministry of the Attorney General's website. But even with power of attorneys, there are nuances that, I think those forms don't necessarily account for. On the will planning side, I mean, when you think about a will, like you're dealing with the administration of your estate, right? Like your assets. So hundreds of thousands, maybe millions of dollars. I don't know that you want to rely on something that you download. I would say, especially in situations where you are a caregiver and you've got beneficiaries of your estate who will require your support after you pass away. So I would say a definitive no if you're in that camp, but otherwise the answer, I guess, is maybe.
Thank you. And I know there it's a bit of a nuanced question and it's specific to unique experiences. So I appreciate the response there. And I'm just mindful of time. We've got a minute left. So I do want to thank Karen and Brendan for joining us today and providing such a wealth of information, tools, and resources for all of our caregivers to take away and learn more. Our guests really find these sessions to be really beneficial and helpful. So thank you both for sharing your time with us today.
Pleasure. Thank you for having us.
Thank you.